I'm Shanna Welsh-Levin with Southern California Real Estate Law. We are your Southern California real estate attorneys, and we protect your biggest investments. So today we're rescuing your real estate investments from COVID-19 laws. So today is a California eviction update, and I'm calling the new AB 3088. It's actually called the COVID-19 Tenant Protection Act of 2020, but I'm calling it our Road to Recovery. So today's presentation we'll call the Road to Recovery. Are we there yet? The last landlord webinar, we presented a run through of 3088 almost in its entirety, although it is very extensive. And so there were a bunch of parts of it that we missed, and I'm not going back to catch those today. I'm actually focusing in today on the biggest impact that the law has had on us and what we're seeing, which is the direction that residential evictions are taking right now. And I do have a little bit of information about commercial, but this presentation is almost entirely about the residential side. Okay, so the almost immediate impact is based on tenancies that existed between March 1st, 2020 through January 31st, 2021. But the new law will also continue to affect how we do residential evictions for the next 5 years. It does not expire. Parts of it expire, but most of it does not expire for 5 years. So how it started versus how it's going, I think this gives you some idea of where I'm going with this. But I'm not going to go all doom and gloom on you just yet, because I'm actually not complaining. You know, this had to happen. There has to be some safeguards for people who are going through COVID-related hardship. So the new law is actually manageable once you can wrap your head around it and once you can really focus on what you need to know. And then we handle the issues that pop up of what we need to learn as we go. But I think everybody's in the same boat here. And this law is going to keep our office busy as we try to help landlords through all of this COVID-related hardship. So how it started, in order to really understand what is in 3088 with regard to residential evictions, you have to understand the Tenant Protection Act of 2019, which I also reference as AB 1482. So as I go through this presentation, I'm going to reference AB 1482 or the Tenant Protection Act of 2019 or the 2019 law as the AB 1482 stuff. This law created a bunch of just cause eviction definitions that were put into this Cal Civil Code section 1946.2, sections B1 and B2. And those definitions are adopted by the AB 3088 law. So by creating this new Civil Code statute, it codified definitions for cause evictions under state law that we didn't have statewide prior to this. We did have some local laws that had definitions of just cause eviction, for cause, and not for cause, at fault and not at fault, but statewide, there was never a broad-ranging law, and now there is. So when you look at AB 1482, it created a rent cap for qualified properties. It defined qualified properties in a way that excluded most single-family residences. And it also created this just cause eviction, these definitions and this application. But what AB 1482 has that the new law does not have are some of these requirements where the tenant has to be in the property for 12 months before it applies, and that the landlord has to pay relocation assistance. That stuff is in the 2019 law and is not in the COVID 2020 law. And I'll go through that more clearly in a moment. So how it's going is that AB 3088 has adopted those definitions from AB 1482, 2019 law, and the AB 3088, 2020 law has created some additional definitions. So the 2020 COVID law defines tenant. It defines its application to tenants who are natural persons except for tenants of commercial properties and except for tenants who are transient occupants in a hotel, motel, single resident occupancy hotel, those sorts of things. It defines something called COVID-19 rental debt, and this term is used throughout the law to describe, quote unquote, the way it's defined in the law is unpaid rent or any other unpaid financial obligation that came due during the covered time period of March 1st, 2020 through January 31st, 2021. And I put a pin in that definition because even though it makes you think that that's the only thing this law applies to, the law applies to a broader range of issues that come up, such as subleasing, such as other kinds of breaches of the lease agreement. Then we have the definition of a protected time period, which is from March 4th to August 31st, 2020. That time period, for any rent that was due and unpaid during that time period, the landlord will never be able to evict a tenant for rent that was unpaid during that time period. They can still collect the rent. And as of March 1st, 2021, you'll be able to go to small claims court and pursue a judgment for that rent, but you'll never be able to file an eviction and succeed based on the non-payment of rent during the protected time period. The transition time period is September 1, 2020 through January 31, 2020. And during this time period, if the tenant pays 25% of the rent during this time period on or before January 31st, then you will not be able to evict a tenant for the rent that was not paid during this time period until 12 months after the time period ends. So you would eventually possibly evict the person, but if they've paid the 25%, you won't be able to do it for a long time. When these time periods are over, February 1st, 2021, the full rent becomes due. Then if you don't if the tenant does not pay the full amount of rent due in February 1st and going forward from there, you will be able to issue notice and pursue an eviction for non-payment of rent due on or after February 1st. Okay, so then AB 3088 created this CCP 1179.03.5. And in this statute, you can look at the statute and it tells you that the court may not find a tenant guilty of unlawful detainer unless it finds that one of the following applies. And it gives basically three sections of reasons that we can evict. Reason number one would be that the tenant was already guilty of unlawful detainer before March 1st, 2020. So before that protected time period began, rent was unpaid for February 2020, a 3-day notice was issued, and for some reason, after that 3-day notice expired, the landlord did not file an eviction against the tenant. And then the courts shut down, and there are landlords who are just getting back to these issues now. In order to establish unlawful detainer, a notice has to have been issued and expired prior to March 1st, 2020. The next section of this reasons we can evict is if, in response to service of the new notice demanding payment of COVID-19 rental debt, as defined, and I defined it for you above, the tenant failed to comply with the requirements of CCP 1179.3. 1179.3 is one of the new laws created by AB 3088, and it provides a pretty lengthy explanation of this declaration procedure. So there's a declaration that the landlord has to serve on the tenant if they haven't paid rent, and then the tenant, and there's also a CDC declaration that the tenant might find, and the tenant has to submit the declaration to the landlord or to the court. And the trick here, and what's also in this same statute, is that when the tenant fails to provide the declaration within the 15 days, then we feel like, okay, we're in the clear, now we can proceed with an eviction. But in fact, the law provides that the declaration may be provided to the court after the eviction has been filed. And if they do that, if the tenant submits it to the court has to set a hearing. And that hearing the purpose of that hearing is to determine whether the case can proceed. I'll go back to this in a minute because there is some specific language that I find very interesting. I have to do one of these hearings, so we've been researching this issue about, what's the issue in this hearing, and so we'll go back over that. The third reason that we can evict right now is if the unlawful detainer arises because of termination of a tenancy based on an at-fault just cause or no-fault just cause, as defined in Civil Code 1946.2 B1 or 2, and then there are some adjustments to those definitions in that statute. But this is why I started with AB 1482, because you can see how the new law, the COVID 2020 law, is borrowing the definitions from the Tenant Protection Act of 2019. So we'll go through those definitions. Civil Code 1946-2 B1 provides the following at-fault cause definitions, and the application of this statute, this statute is part of the AB 1482. So these definitions apply to non-exempt properties where the tenant has been there for 12 months or more, and that's not really what we're talking about today, but I just want you to be aware of where these come from. The new law doesn't adopt those requirements of exempt or non-exempt property or how long the tenant has been there. The new law applies to all tenants, whether it's a single family residence, whether it's exempt or non-exempt from the AB 1482 2019 law. But that law provides these definitions. At-fault just cause includes default in payment of rent, breach of a material term of the lease, nuisance or waste, expiration of a fixed term lease, but it does require that the landlord make a written request to the tenant to renew the lease, and then the tenant has to refuse renewing the lease. Criminal activity, tenant refusal to allow entry, assigning or subleasing, use of the premises for an unlawful purpose, employee refusal to vacate after termination, and the tenant fails to deliver possession after the tenant provides notice of their intent to terminate and the landlord has accepted that notice. If you look at the new law, so the new law borrows all these definitions, but it says you cannot evict anyone for default in payment of rent or breach of material term of the lease or assigning or subleasing. Breach of a material term of the lease is the way that we're interpreting it, because a lot of the way that it's written, the court ultimately has some discretion about whether the reason used for eviction is a COVID-related hardship. And so things like subleasing are considered a COVID-related hardship. We look at the policy behind the new law, which is that if someone has lost their income and can't afford their rent because of the pandemic, and they get evicted, they are going to go and double up with family or friends. And if they do that, then we create higher occupancy living situations. And that higher occupancy will have a tendency to make the pandemic worse because people will be living together in close quarters and spreading disease. So if you look at that reason, evictions for breach of a material term of the lease are going to be interpreted as much as possible to fall under the definition of COVID-related hardship. And so you get to an issue such as, somebody has a pet that they shouldn't have. Is that a COVID-related hardship? No, it isn't. Are we going to interpret the law to include that as requiring a 15-day notice and a declaration? Yes, we are, because that is the type of eviction that falls under the Civil Code Section 1161, Sections 2 and 3, and both of those sections now have been amended to reference the new COVID 2020 law, and that law requires the 15-day notice. So in a roundabout way, we've reached the conclusion that we need to include the 15-day notices and use the declarations and give people the benefit of the doubt that they have a COVID-related hardship, and assume that the court's going to opt to keep people in place if at all possible. Okay, no fault just cause definitions under the 2019 Tenant Protection Act are intent to occupy by the owner or their spouse, domestic partner, children, grandchildren, parents, or grandparents, withdrawal of the property from the rental market, defined very broadly, order by government agency relating to habitability, order by government agency to vacate the premises, local ordinance that necessitates vacating the premises, and substantial remodel as defined more broadly in that law. But you see that the new law adopts these definitions. The COVID 2020 law adopts all of these definitions, but it narrows two of them. So we still have intent to occupy by the owner, etc. We have withdrawal of the property from the rental market, but only if the property is in escrow to a bona fide purchaser with the intent to occupy the residence. So the purchaser is going to occupy the residence after the purchase, and the seller is not a corporation. That means that you can't do an end run around the law to evict someone but just by saying, I'm going to remove it from the market and I'm going to let it sit vacant. You actually have to be in escrow with all of these requirements met. And then the substantial remodel definition has been narrowed to only apply if the substantial remodel is required to address habitability issues. So that's a little harder to meet those requirements now. Okay, so yeah, 2020, how it started and how it's going. I think the picture says it all. Just to recap, the COVID-19 Tenant Relief Act of 2020 prevents residential evictions that are without just cause. It almost completely prevents evictions for non-payment of rent or COVID-related debt. And it adopts most of the at-fault and no-fault just cause reasons from the AB 1482 law, but does not adopt the one-year tenancy requirement or the relocation assistance requirements of the 2019 law. And then it adds the additional reasons why you can evict, that you've established unlawful detainer prior to March 1st, 2020, or the tenant has failed to comply with this declaration procedure. And I'll tell you, as far as tenants complying with the declaration procedure, a tenant would have to be crazy not to try, because the definition of the COVID hardship and all the reasons on the declarations that you have to check the boxes, anybody could find one of those boxes to check. So let's assume that any tenant who claims the hardship may be able to fulfill that requirement. It's pretty likely. So the other outcome of the new law is that we have a zillion notices whenever we are serving tenants now. It went from just a 3-day notice to 4, 5, sometimes 6 documents that have to be served on each tenant. And so the new notices for AB 3088 and AB 1482 are this list. So we have this notice from the state of California pursuant to Code of Civil Procedure 1179.4. This is just a boilerplate notice. It doesn't need any personalization. You can print it right out and serve it on the tenant without making any changes to it. It was supposed to be served on all tenants who had missed any payment of rent since March 1st, and it was supposed to be served by September 30th. The law also states that you cannot serve a 15-day notice until this document has been served. The document may be served concurrently with a 15-day notice. What that means is if you didn't serve the notice by September 30th, 2020, and now you need to serve a 15-day notice, you just serve the notice from the state of California with the 15-day notice and you're covered. So if you got a 15-day notice, you've also got this notice from the state of California. We're checking to make sure that all of our clients have served the AB 1482 notice of exempt or non-exempt status. That was due to be served by August 1st, 2020, and then must be incorporated into all leases that were new leases after July 1st, 2020. But you can still serve it today. The reason is that if you haven't served it and the tenant chooses to raise that as an issue in your eviction, you could lose your eviction case by not having served that notice. So we're making sure that we're covered there. Then we have these new 15-day notices. There are different notice language requirements for a notice based on rent due during the protected period or any kind of COVID-related financial issue during the protected period, and different language for a 15-day notice for the transition period. These notices, the 15-day period is counted not as 15 calendar days, but basically 15 court days. So the 15 days does not include weekends and holidays. It basically comes out to about 20 days. And we are making sure that any notice served pursuant to California Code of Civil Procedure 1161, Section 2 or 3 uses this new type of notice, even if it's for something like having a pet, even if it's for something that's not a COVID, not our definition or our obvious definition of a COVID financial hardship. So 1161 covers any kind of 3-day notice to pay or quit that's based on non-payment of rent, cure, breach, or quit, or subleasing without the right pursuant to your lease. The 15-day notices must be accompanied by a California Declaration of COVID hardship. That's a boilerplate form with a signature line on the bottom. The tenant signs it and either returns it to the landlord or returns it to the court, and they have claimed their COVID hardship. There's very little requirement for them to prove that they actually have the COVID hardship, but if they file it with the court, then we have the hearing that I mentioned before. So then we've got 30 or 60-day notices now require just cause reasons. You can't use a 30 or 60-day notice for no cause anymore. You have to provide a just cause. And there's a presumption under the new law that if you don't have just cause, or if you have a cause that is not supported by any facts, then you may be retaliating against the tenant for having a COVID hardship. And that's a position that will cause you to lose your eviction case. I mentioned the CDC declaration because I've gone, 9 rounds with everybody I've talked to, whether it's required to be served on the tenant like the California Declaration. And I've confirmed that it does not have to be served on the tenant. So the landlord doesn't have to provide it. The tenant has to find it themselves. And it may be used in lieu of the California Declaration by, quote unquote, a covered person under the CDC order. The CDC order, a definition of covered person is very narrow. They have to have sought financial assistance. There's lots of different things in there that I think it's very difficult for a tenant to comply with. Earn no more than $99,000 annual income or $198,000 if they file jointly. Unable to pay full rent or make full housing payment due to substantial loss of household income. They have to declare that they're using best efforts to make timely partial payments or full payments. If evicted, they declare that they would have to move into a homeless shelter or likely become homeless. So it's a pretty narrow thing for someone to qualify for. Okay, in addition to these notices, and let me go back. So let's say somebody hasn't paid rent. We've got to serve them with notice from the state of California, the AB 1482 notice, the 15-day notice for this time period, a 15-day notice for that time period, declarations with each notice. And we've even been throwing in some 30 days and 60-day notices if that seems appropriate. So we've got at least 6 notices served on one tenant for non-payment of rent. High income earners, when I see that the rent for a property is $3,500 to $4,000 or more, then I inquire of the landlord whether they obtained any financial documentation from the tenant when the tenant was moving in. The reason I'm asking that is because the new law provides the landlord with an opportunity to get documentation supporting the COVID financial distress from a high income earner. So the high income earner is defined as someone whose annual household income is 130% of the median income pursuant to the Department of Housing and Community Development's official state income limits for 2020 for the county where the property is located. So if the landlord has some proof of income from before COVID, then the tenant must provide proof of income during COVID to show the COVID-related hardship. In order to trigger this procedure, this obligation, you have to include specific statutory language in your 15-day notices. So in these 15-day notices, if you think you have a high income earner as a tenant, you add a couple of paragraphs to the notice, and it notifies them that they may have to produce documentation of their financial distress. The median income for certain counties in California, the counties where we have cases, San Diego County was $92,700, Riverside County was $75,300, Orange County was $103,000, Los Angeles County $77,300. That makes the median income for San Diego County $120,510. So that's household income. A lot of people will meet that threshold. A lot of people who aren't paying rent right now will still meet that threshold. And so, Riverside is $97,000, Orange County it's $133,000, LA County it's $100,000. We'll probably find a lot of high income earners in our upcoming evictions, so we're including that language where we can. How it started. 2020 started, I was teaching classes on AB 1482 and I was ready, AB 1482, I'm coming for you. And now I'm just buried in paper. And I have a stack of statutes printed out that I reference regularly and outlines that I am using to make sure I counsel people correctly. In addition to the new notices and the new laws, we have new court procedures that derive from the new laws. The local unlawful detainer case cover sheet has been issued by San Diego Superior Court. It's a very brief cover sheet, but it helps the clerk know what to do with the case, and I assume the judge as well. The UD 100 complaint form, which is a standard judicial counsel form that we've been using for years, has, as of September 1st, been updated to include information regarding AB 1482. That's the 2019 law. So there are new paragraphs in there, boxes to check to explain whether your eviction is subject to the AB 1482 requirements. And then in response to the COVID, I don't know why this is an X, but it should be a check. In response to the COVID, the new COVID law, the plaintiff's mandatory cover sheet and supplemental allegations is really more of an addendum to the complaint, because both the complaint and this mandatory cover sheet have to be verified by the plaintiff's signature. So if the plaintiff has to file the eviction, you have to include this new UD 101 form, and it has all of the questions relating to the COVID 2020 law. So the UD 100 complaint has been adjusted to comply and to trigger questions relating to the AB 1482 2019 law. And then this cover sheet is being added in response to the COVID 2020 law. And so the tenant declaration comes into play, and I'll use an example of the first one that I've had. When the tenant signs the declaration, these are all the things that they are identifying. Loss of income has been caused by COVID-19. Actually, they have to have one or more of the following: loss of income, increased out-of-pocket expenses relating to performing essential work during COVID-19 pandemic, increased expenses directly related to the health impacts of COVID-19, blanket, let's do childcare, elderly, disabled or sick family member responsibilities that are directly related to COVID-19, increased costs for family-related responsibilities, other circumstances directly related to COVID-19 that reduce income or increase expenses, or a blanket declaration that any public assistance, including unemployment, SDI, paid family leave, didn't make up the difference for their hardship. But in particular, when the tenant files this declaration with the court, the new CCP 1179.03 sections B and C provides that the court has to set a hearing in which the court seeks to find, the court notices the parties within 5 to 10 days and seeks to find that the tenant's failure to return a declaration of COVID-19 related financial distress within the time required, so within that 15 days, if they fail to provide the declaration, that they did so because of mistake, inadvertence, surprise, or excusable neglect, as those terms are defined in another statute. So the hearing that I have coming up, we served the COVID declaration on the tenants, didn't hear anything. We relied on the presumption that if they weren't going to give that declaration back to us, that they weren't going to respond to the eviction. And so we're thinking, okay, we'll file it, we'll see if they respond. But even if they do, we're in the clear because they didn't comply with the law. Well, the tenants responded to the eviction lawsuit, but they filed a declaration with the court. So the court set this hearing, and I went in and I said, Your Honor, what's the purpose of this hearing? I don't understand how to prepare for it. And she said, well, let's just say it's regarding AB 3088. So then I scrambled and I looked at the statute and saw this. So what the court is going to be looking for in this hearing is that the reason that the tenant caused us to file a lawsuit, failed to return the declaration in time to notify us that we should not proceed, was due to their own mistake, inadvertence, surprise, or excusable neglect. So I will keep you posted on how that goes. And in fact, that eviction isn't really based on non-payment of rent, but we serve the declaration just to be on the safe side. Oops. A couple of features that I have talked to people about extensively since the law was issued is the small claims court exception. So for rent that's due and unpaid from March 1st, 2020 through January 31st, 2021, landlords will be able to pursue a judgment for that rent, just that rent, for that protected and transition time period in small claims court, even if the rent exceeds the $10,000 cap of what's usually the requirement in small claims court, and even if the landlord has filed a couple of other small claims lawsuits. There are limitations on how much you can recover in small claims court. The broad overriding one is that $10,000 cap, but there's also a cap for people who have filed, I think, 2 or more small claims cases in the last year. And then retaliatory eviction. So I've been warning people who desperately need to get the tenant out and a new tenant in, who desperately need the funds for the rent, who desperately want to move forward with evictions, that look, we can't try to make up something. We can't do an end run around the law, because if a court sees that we're doing this basically in retaliation of the COVID hardship, we're trying to avoid the COVID hardship and evict them anyway, there are some serious repercussions and your case will be dismissed. So we need to be careful of that. Although that law expires February 1st, 2021, and I guess after that you can retaliate against tenants. I don't know. I'm not sure why it expires then, but it does. Okay, so if you want to know about commercial eviction moratoria, to be honest, I can't find any. I can't find any ongoing eviction moratoria. The city of San Diego has something going on. The only thing that's happened recently is that Governor Newsom did give local jurisdictions authority to extend any commercial eviction moratorium through March 30th, 2021. That means if there was a commercial eviction moratorium still in place, it could be extended I'm not sure if you could create a new one under the governor's order. Most of the commercial eviction moratoria expired prior to this new order taking place. The city of San Diego, technically, it seems to have expired at the end of September, but there is a repayment period through December 30th, 2020. As far as I can tell, it's not preventing anyone from evicting a commercial tenant, but it is giving them the right to repay. Los Angeles, they have something that expires October 30th or 31st, 2020, and there's no indication that they've decided to extend that one. So that's all I could find in my research. I'd be happy to know if I'm missing something. It would be appreciated if someone wants to let me know. And there were certainly some commercial evictions going on when I was in court the other day. All right, how it started, we're pretty good going into 2020, ready for action. And now, I don't know, Ethel, what do you think? I'm calling Rebecca my Ethel. And so I would love to field some questions and let me know. We can talk now, or if you want to keep your question private. I'm booked today, but I have some time tomorrow and next week.